Welcome again. My name is Danny Kim, and I'm a doctor of pharmacy student here in Northeastern, and one of the brains behind the series. Today, we bring together Matt and Nate as a part of the broader series, Health Sciences Entrepreneurship, webinar series, Transforming Digital Health. And as many of you know, if you've joined, our previous sessions, you'll know that digital health has been one of the hottest topics, probably of 2020 and 2021, as we've seen a surge of interest and attention, given to the space, due to COVID-19. Some even go on to say that, COVID-19 has accelerated the adoption of digital health technologies and platforms, and many of you might know this from perhaps interacting with telehealth platforms, or if you're really out there, maybe thinking about digital therapeutics and other services in the arena that derive the power of technologies and apply them to the area of healthcare. Now, as many things go, we cannot leave legal issues out of this space as well. And unlike different spaces that we might be familiar with in business and technology, healthcare is often bounded by laws and legal regulations, as we aim to improve upon the lives of folks, much more than just focusing on the convenience or efficiency. So in that matter, we wanted to use this day's session to go over the legal issues and legal kind of hurdles that the companies need to perhaps jump through, when they enter the space. Previously, we looked at the topic of digital therapeutics, chronic disease management, and data management in healthcare, and how all that kind of ties in. And I believe the legal issue is as big, or if not, probably one of the most often overlooked topic when the entrepreneur enters the space. So I'm very glad that we have Matt Fisher on the call with us today. So I've known Matt for now about 3 years now. I remember hosting you at HSC and Vital event a few years back, and that was when I started getting my feet wet in the industry as well. And I think I was asking around for who the best person in Boston to ask about Hipaa is. And if you don't know what Hipaa is, you'll definitely get a chance to learn about it today. And Matt's name came up on the spot. I believe it was the Flair Capital event that I think we first met, and very gladly volunteered his time to come to Northeastern to share his knowledge and expertise. So Matt is a general counsel for Carium, a telehealth platform company, and he's responsible for all legal functions in the company and helps to ensure that operations meet the requirements of applicable healthcare laws and regulations. And he works to find creative solutions when needed, and keeps an eye on complications that can come up from working in the healthcare industry. So prior to joining his company currently, Matt practiced for over a dozen years at a mid-sized law firm, where Matt advised clients across healthcare spectrum on healthcare laws and regulations and general business matters. And then we have Daniel O'Connor. Nate is another lawyer on the call. He's a director of major gifts at NU, where he oversees fundraising for Health Sciences Entrepreneurs Program. And he works with alumni, friends, and foundations to guide them in achieving their philanthropic goals and to maximize their impacts in university. Now, before his time at Northeastern, he spent some time in Boston and Silicon Valley for nearly a decade and did business development and alumni relations. And he has a depth of knowledge about health and life sciences industries and their entrepreneurial ecosystems as well. Prior to the education days, he was an equities trader and subsequently practiced corporate law roles at 2 Boston-based hedge funds. So we're definitely excited to have both of you. And for the sake of time, Nate, I'll pass the baton over to you.
Sounds great. Thanks, Danny. Thanks for that great introduction. Welcome, Matt. Great to see you here. Thanks for making the time for our call this afternoon, this evening. Matt, I know you have some ideas, some material that you definitely want to cover. So I'm going to defer to you to sort of choose the kickoff topic. And I would advise, I guess I'll just say some housekeeping suggestions for the rest of the call. If anybody, if during the time Matt's making a point or discussing a specific subject matter, please feel free to ask questions in the chat. Danny and I will be monitoring the chat, and we'll make sure that your question is covered. And then also Matt has said that if you have, please don't hold your question. So if you have a question during the time he's discussing something, please make sure that you feel free to interject and add a comment or your question at that time. So Matt, I'll defer to you in terms of kicking us off in the interest of time. Maybe just start wherever you want to start.
Yeah, no, thank you. And, Nate and Danny, thanks for having me on. It's, a pleasure to be able to talk virtually. It's, hopefully, as I think is becoming commonplace, soon I'm optimistic we'll be able to do this in person again. So it was great to actually come to the Northeastern campus a couple of years ago. But, kind of as Nate said, certainly don't hesitate to ask questions. I always like it when things are more interactive. I can talk about things that interest me, but then again, that might not be exactly what's on the forefront of mind for all you. So it's, definitely want to make sure that I'm capturing concerns. So I am going to bring up some slides that I had prepared. And actually, I guess I should start off this way. If anyone has ever been to a legal conference, you'd be used to this, but I'm just going to give an overview of issues. None of this is actually legal advice directly for you. We were kind of talking beforehand that, it can often sound self-serving, but, kind of one of the best things that I think a startup, especially in the healthcare space, can do pretty early on is to talk to a lawyer, and not just any lawyer, but probably, a lawyer that understands the healthcare industry and the healthcare space, because there are, as Danny already mentioned, a number of regulations that are unique and special to healthcare. And especially when you're thinking about it from, kind of the operational perspective, which is often where I'm working with companies, and certainly what I'm doing with the company where I'm working now, the regulations can drive how that business can operate from a lot of different perspectives. So kind of the way I like to picture the healthcare regulatory landscape is that it's like a maze or a labyrinth. There is definitely a path through there, but it's not going to be that straight line that a lot of businesses like to take. It's, kind of when I was in private practice, what I'd tell a lot of like physician or healthcare practice entities that I worked with, oftentimes you could have what sounds like the best idea and it makes complete business sense, but because you're in healthcare, it's not going to be allowed. Or it's not going to be allowed in exactly the way that you initially thought. So it's, what I always like to say is, through all my years of practice, I could count on one hand the number of times where I had to tell a client flat out, it's not possible to do what you want to do. Most of the other times it was, okay, I see what your end goal is, or actually kind of the first thing is you told me what your end goal is, but now let's talk about it. Like give me a sense of what you're thinking about from the business perspective. Like, why are you trying to do this? Or, really, what are you thinking about in trying to get to this place? And then we can be able to chart a course. And the course is going to be guided and influenced by the regulations. But ultimately, it's, it's that zigzagging path, but very often you can get there. But again, as I said, it's going to be, an unexpected journey. And, kind of emphasizing the fact that, the regulations can be confusing at times. This doesn't necessarily apply to like HIPAA or, the privacy and security issues that a lot of digital health companies think of. But I'm going to touch on some of the other, more fraud and abuse driven laws, which, digital health companies can certainly butt up against. But when it comes to those types of laws, even the courts throw up their hands. I'm going to very horribly paraphrase this, but there is a, language in a decision from a federal district court a number of years ago, where they basically described healthcare regulations as a morass and some of the worst regulations that are out there, and so confusing that no one should have to work their way through them. While I would maybe say that, if you're getting to court like that, you are not dealing with the best of circumstances, and usually those cases are, kind of the old legal adage of bad facts make bad law. It is certainly true that the regs are, very convoluted, and frankly, at times you can find contradictions from one place to another, even dealing with the same subject. One of the examples that, I don't know if I've specifically confirmed this, but I've always heard that there was one type of regulation where if you made a phone call from within an exam room with a patient, you had to do it in a certain way, but if you stepped out into the hallway, you could do it in a completely different way. And you're doing the same type of service. So it really does make a lot of difference, how things are being done, and you want to make sure you have a good understanding of what's happening. So kind of with that, just a really quick overview, and then we'll get, dive into some of these, frankly, in a lot more depth than others, but, a quick lay of the legal landscape. And again, I'm going to come at this from more of the, the healthcare service perspective. I think Danny mentioned that there was a discussion of FDA approved, the FDA process in another session. FDA regulation is, if you're talking about a medical device or a drug, or now software as a medical device, which is becoming a very frustrating area for folks, because the FDA has pretty much refused to come out with clear guidance of when they're actually going to want to regulate software. They seem to be trying to do as much as they possibly can not to, but it will certainly fall under its jurisdiction at some points. But I'm focused more on, as I said, kind of delivery of services. So the first couple of the Stark Law and anti-kickback statute, I would not be surprised if no one's ever heard of those before, but those are actually very fundamental fraud and abuse laws. And if you're in private, if you're an attorney in practice, those are two of the kind of core laws that you need to know about, because those can really shape how a business can operate. HIPAA, that's where I'll spend most of the time. I kind of like to analogize HIPAA to the Miranda rules, or Miranda rights. I feel like most people, just because they've watched Law and Order or some other legal, right, kind of show like that on TV, have heard Miranda. And yep, at this point in time, especially now with the discussions around COVID vaccine passports, which I will just say are ruining my Twitter feed at the moment, everyone has heard of HIPAA and no one gets it right, even within the healthcare industry. Or, well, very, very rarely, because, Nate will appreciate this, but as a lawyer, you very rarely speak in absolutes. That there is always, kind of I remember one of the first lessons I got in law school was the most common answer you'll give to a client about a question is, it depends. And then you use that to talk through and analyze the issues. But so HIPAA, then information blocking. So we're recording this on April 6th. This regulation became effective on April 5th. So we are, I guess, almost 2 full days into this new era of really expanding access to data with exceptions, which is common for regulations. And then the FTC. FTC is important because, if you don't fall within the traditional healthcare space, so thinking more like direct to consumer, you might think, oh, I've got a free pass. Yes, you might have a free pass from a number of the healthcare specific regulations, but you are still going to have to worry about some agency overseeing you. And the FTC actually has been active. They had a fine, I think, in late 2020 with a healthcare service that was geared towards airline travel that made some apparently extremely false representations about the security of its services, which, obviously, if I'm saying they're false statements, it turned out that data could be accessible, and lo and behold, there was a breach. So even though it wasn't HIPAA, as we'll kind of discuss, the FTC had jurisdiction to step in and issue a fine there. And then the other layer are the states, because you have to remember we're a federal system when it comes to laws. So you have the federal government on the top, but then you have all the states you can work within the boundaries of either where the federal government cannot legislate or become more restrictive than kind of those outside parameters established by the federal government. So now, as I said, let's think about what type of service are you talking about? So if we're talking digital health, obviously that is a very broad category. So if I was first talking to a company, one of the first questions I would ask is, when you're thinking about, okay, what form of service you're talking about? Are you talking about, is it telehealth? Are you talking about a medical device? Are you talking about some type of consumer wearable? And also, what are you providing? Are you just tracking information? Are you analyzing that information? Are you feeding the information somewhere else? Just trying to get a sense of, where are you trying to fit within the industry? Because that, as I said, that's going to help to figure out, okay, what set of regulations or laws are actually going to apply to you. So, as I said, some of the other gating questions that you're going to think about are, who are your target users? So the user, and there could be layers of users. So for example, if you're direct to consumer, so, say you're, I'll just go with the example of what I've got on my own wrist. So I've got an Apple Watch. So, that in some instances, you might think that's, a medical device. It can track my pulse. It can track my, it can act as a pulse oximeter. It can track, can do an ECG, leaving aside the, the clinical validity of the data that it can collect. It might look like a medical device, but it's sold direct to consumer. It's not meant for medical purposes. It's meant for general, informational purposes. So that, that's a direct to consumer product where you're not going to fall within the general healthcare industry. But what if you're using the Apple Watch, or you're using some other type of wearable device, and you're feeding it to a physician's office, and you're telling the physician's office, okay, give this to your patients so they can be able to send data back to you. So now you're talking maybe about helping with some form of remote patient monitoring. Now you're starting to shift, the scenario, because now you're selling a service to a physician, so or to a hospital. So you're selling directly into the healthcare industry and trying to provide a service that's helping to inform the clinical decision making, or gathering more data for those actual healthcare professionals. So now by going that route, so selling a service that, even if at the end of the day gets passed through onto a patient or individual end user, you're providing a service for the benefit of, let's call it the traditional healthcare system. So now you're going to be swept within the full scope of the regulations. Some of the other things that I'll often ask about are, who's going to be responsible for paying for the service? Is it that, the end user is just paying you a flat fee, or, in that kind of that latter example where you're helping for a service to a professional entity, is that professional entity then billing either Medicare, Medicaid, or a commercial insurance company like Blue Cross, or here in Massachusetts like Harvard Pilgrim or Tufts? Are they billing one of those? Because if you're getting money from an insurance company, or at least getting a piece of money from an insurance company, that's where that's really where you're going to start to have the fraud and abuse regulations, which I'll touch on once we actually get into the specific regulations first. And that's where that's where you have to get really careful. Another major question that has, I would say, exploded in prominence as a result of just digital health and technology writ large is, what data do you want to collect, and what are you going to do with that data? What do you want to, and how long do you want to keep holding on to that data, and in what form? Again, depending on where you fit, there are going to be very different answers of what can happen with that data, regardless of what your plans might be. But it's always helpful to understand up front, what would you like to do? It's like, I remember talking with one company, and I think they were trying to provide some form of cardiac interpretation of either EKG or electrocardiogram data or something similar to that. And when they first talked to me, they said, "Oh, we just want to collect de-identified information." And de-identification is, a specific kind of term of art under HIPAA. So they thought, okay, we're going to be collecting. We want to collect all this, basically unidentified data, so you don't know who it's coming from or who it relates to, and then we can be able to do a lot. We can be able to keep it, we might be able to aggregate it, we might be able to create analytic tools off of it, we might be able to sell it or do something with it. And then just because this is I think either my nature or maybe what got drilled into me in law school, I started to ask questions. I was kind of wondering, okay, so what data points are you actually still going to be keeping in there? They said, well, and I don't know if this is going to necessarily be completely accurate, but I'm pretty sure they said we're going to need, what gender the patient was. We're going to need to know approximate age of the patient, and a couple other, kind of, I would say, personal history style background details. And they started telling me all this, and I very quickly told them that's not de-identified information. That HIPAA said lays out what needs to be removed. So all of a sudden they thought they were going through, the bright door where they had no problems, and I pushed them off to the side and said, no, you actually have a lot of things that you need to consider, and you're going to be in a much different position than you think you're going in. So again, that's why I said up front, I think it's very important for digital health companies to ask questions and to seek guidance very early on, because it can influence, how your business model might be. Another example in that direction, I talked to a company that was trying to create a secure messaging platform, and what they wanted to do was, or at least the original idea when they first talked to me was, we're going to go directly and target the physicians and get the physicians to sign up. And it's meant to be a secure messaging, mostly intra-facility or intra-provider or clinician. So, really trying to promote the ability for clinicians to collaborate and be able to, share information and, hopefully enhance the ability to treat. But as I said, what they were thinking is we're going to get individual physicians to sign up, and then from practice A be able to talk to someone at practice B, and basically do that kind of the old traditional hallway consult, but now electronically. So I think that's a great idea, and I think it's something that is probably definitely needed. But I said, well, the problem is you're trying to say you have individual physicians signing up for this service. Unfortunately, the way a lot of practices are constructed and the way that HIPAA looks at it, an employed physician has no right as an individual to agree to something either on behalf of the organization or to send patient information, outside where there might not be there might not actually be an existing treatment relationship, or
privileged relationship. Yeah.
There might not be an actual appropriate relationship where you can be sending it. So I said, if you're trying to create this more kind of enterprise style platform, you're going to want to focus on contracting with the organization, because you're providing a service to them. You're going to be a business associate, and you're going to need to make sure that you're appropriately protecting it. So they said, okay, that's very helpful information. Didn't hear from them for a few weeks, and then luckily, in the rare instance, after thinking I had completely scared them away, they actually did call back, and I got to work with them. But it does just, I think, go to show that it can be tough to think through all the permutations when you don't actually know what all the different doors could be that you might be opening based on what you're going to be doing. So kind of with all that background, let's talk about some of the regulations and laws a little bit more specifically. So as I said, very fundamental for, at least for me as a lawyer in the healthcare field, are to know the fraud and abuse laws. When you practice in this area as a lawyer, these are probably, if you want to look at it as kind of like a holy trinity of laws, it would be Stark, Anti-Kickback, and HIPAA are going to be that core, and the one that, especially for me going to like legal conferences, those are the ones that are always discussed and the ones that you're always getting education on. So looking at, so taking fraud and abuse first, kind of the way I always like to see it is, or think about it, is that Stark and Anti-Kickback are kind of two sides of the same coin. They're both looking at referral relationships between provider or between clinicians or facilities like a hospital. I will be very honest, this is going to be a very gross oversimplification of how these laws operate, because these are two of the most extremely nuanced laws that you'll work with. I remember when I was first starting to do healthcare law and starting to go to conferences and learn about it, I had the privilege to meet, and actually I'm still friends with, one of the individuals who was drafted some of the original regulations to implement the Stark Law. And the advice that he gave me, and which I will actually still trot out to clients today, is the day that I don't double check something in the regulations is a day I should stop practicing in the healthcare field, because a single fact is going to change the analysis of whether something is permissible and you're going to be fined, or you're going to violate the law and potentially owe a lot of money back to the government. And depending on which law you're talking about, potentially lose the ability to bill the government, which for most practices means you no longer have a practice. So the reason I said it's two sides of the same coin, though, is Stark Law is a civil law. So that means you don't actually have to have an intent to violate the law. It is what's called a strict liability law. So you either, when it's applicable, you're either meeting exactly what it tells you to do and you've structured your relationship or your transaction appropriately, or you don't. And if you don't, as I said, you're going to owe, that taints the entire relationship between the parties. And by the entire relationship, I mean all of the billing to Medicare that occurred, and Medicaid actually. A few years ago, there was debate as to whether it applied to Medicaid, but that has been clarified in the clear of it applies to Medicaid. But what it means is if you violate and you haven't structured your relationship appropriately, any billings that you created, so any revenue that you generated from services is going to be subject to be clawback by the government along with penalties. So while the flat the flat statement is referrals are bad, and certainly paying for referrals is bad, there are at this point over 30 exceptions now. It's hard to keep track. There were actually a number of recent revisions that went into effect in early December that added a bunch of new exceptions kind of around value-based care, which is actually very helpful with where a lot of digital health companies try to focus, because you're trying to innovate and disrupt in the industry, adding in greater freedom for what can happen. But kind of the key is with the exceptions, they will have a lot of different elements that it must be in agreement. And if you're missing one of those elements, then you haven't complied. So the anti-kickback statute is the same type of premise. It's actually a little broader. I didn't dive into it, but Stark only applies to what are called designated health services, which are a defined set of services. So it doesn't apply to everything that could possibly happen. So like, for example, if you go to an ambulatory surgery center, doesn't apply at all to ASCs. I would maybe cynically say that means they have a great lobby, or they just weren't in prevalent use when the law was initially passed, which might be a combination of the two. But so anti-kickback statute is much broader, and it could actually be swept in to look at relationships that maybe don't even necessarily involve a federal healthcare program. It could be that maybe you've carved out saying this relationship won't apply to any Medicare patients, but it's only commercial, but maybe that helps to drive Medicare patients referrals, and all of a sudden now you could still have a problem. But the anti-kickback statute, the difference is it's a criminal law, which means you actually have to have some type of intent. There is not actually a requirement to have a specific intent, and in fact, you don't even have to knowingly violate the anti-kickback statute to have a problem under it. That kind of the intent standard, both by case law and by regulation, has been eroded quite a bit. So it can be basically implied that you have a violation, which can make it fairly tricky. Kind of though, one of the hallmarks though is something called the one purpose test. And this comes out of case law. And the one purpose is that you could have 100 perfectly valid reasons for the relationship, but if just you add on 101st, that and that reason is, well, we're doing this because we know you're going to refer us patients and we're going to be able to bill for those services, you've now killed your relationship because you have one bad intent. So, when you're thinking about these things, one of the first things is try to discuss things verbally. Don't put a lot of stuff in writing. There were actually a couple of times where I saw stuff in writing, which then made me respond to my client of, please stop talking about this potential idea, because you've now created a lot of danger by basically admitting, which is probably in most cases the real purpose for most relationships in healthcare, is you actually wanted the patients, but you just can't say it. But again, like Stark, there are also a lot of safe harbors. Kind of the difference though is you don't actually have to specifically comply with all the elements of a safe harbor. Obviously, if you do, then it's much safer. But if you don't, then you enter into a gray area where you're really looking at what's the purpose and the intent behind the relationship, and you try to document your way around it, which frankly is kind of in reality where you end up with a lot of stuff. So how does this apply to digital health? It applies because, say you're a telehealth company and you're helping to provide services that can be billed to insurance. It's not just an out-of-pocket payment for the services. If the service can end up being billed to insurance, you're going to have to worry about this, because you're going to want to make sure, do we have, is there an improper referral relationship that was established with, say, a primary care practice? Maybe you're an independent company and you're trying to provide backup, how are the referrals being driven? How are you structuring it? Or maybe you're having people on the Moonlight to provide these services. You're definitely going to need to be thinking about, what are all the different financial relationships people might have, and thinking and paying attention again to how you structure it. So, as I said, HIPAA is where I do actually want to focus, I think, the most. That is certainly the one that most digital health companies that I talk to would ask about with the highest degree of frequency. And I would say that is because HIPAA is about privacy and security. Even though the main purpose of the HIPAA law doesn't actually deal with data protection or data usage, it actually, the funny thing is the bulk of the law deals with insurance and portability of insurance. So, pre-ACA, you weren't guaranteed to have insurance. So you wanted to make sure if you left an employer, you could actually stay insured, which was a major component of HIPAA, as well as introducing electronic transaction standards for billing of healthcare services, which is still actually, then that piece actually kind of funnels back into HIPAA or the privacy and security pieces in an interesting way. But also the first thing is, if you're approached by a consultant who spells it with 2 P's and does that consistently, run away. It is not 2 P's. There's a reason why there are a lot of jokes around a hippo, because it's it just underscores the way that spelling is not always done accurately.
Matt, can you just mention? Danny asked a great question. How has HIPAA been impacted by COVID?
Yep, that is a great question. So so long as the public health emergency, which was declared very early, actually maybe not very early on, but in March of I guess it was somewhere around like March 16th or so of 2020, a public health emergency was declared. So the public health emergency allowed the different agencies to exercise a lot of discretionary authority to either waive enforcement of existing regulations or implement new changes. So with respect to HIPAA, there was enforcement discretion that was exercised, or well, the key enforcement discretion that was exercised was the statement that any type of non-public facing video conferencing software or platform could be utilized to provide telehealth-based services. So that meant you could use, for example, a Zoom. Zoom actually does have a healthcare specific service, but you could use general Zoom, or you could use FaceTime, or you could use Skype, which always seemed to generate a lot of discussion, even though to the best of my knowledge, they'd never signed a business associate agreement. Or you could use Facebook Messenger, because Facebook Messenger has private video conferencing. You cannot use Facebook Live though, because Facebook Live was public facing.
Yeah.
So you'd want, so as long as you're, making a good faith effort to put something like that in place and doing the best you could to not blatantly disregard privacy, you could use any, again, publicly available service. My issue with how that guidance came out is that was the focus of it. But then when you actually read the whole document, once you got past, you can use private facing, publicly available or generally available consumer services, it said, but there are also a lot of a lot of services out there that do meet HIPAA standards and will comply with the requirements of HIPAA. That piece didn't get emphasized. And frankly, I think that was a bit of a danger, because a lot of practices just rushed to throw stuff together because there was not, they weren't prepared for the shift of not being able to have a single patient come in the door. And in that rush, you got a lot of, you kind of skip past the consider implementation of things, and obviously this is kind of ignoring the fact that, telehealth had been a buzzword within the industry for, years. It's been in existence for decades, but there hadn't been widespread adoption. Now all of a sudden you had, things springing up overnight saying they could offer it, kind of similar to what happened when the Meaningful Use program was created to provide government money for implementation of electronic medical records. You had these, everyone was adding video conferencing, because if you had technology, you were trying to create that pivot point and just get in the door. So it didn't necessarily create the best workflows. And again, it kind of ignored the fact that there were a lot of platforms that are already existed that I think frankly would have been better options. And then you wouldn't have to worry about, when is that public health emergency going to end, and when are the regulations overnight going to snap back into place, unless there's somehow some type of discretion exercise to allow a kind of a graceful landing period. But kind of going back to the beginning point of it is, all of this happened just because there's a public health emergency. The second that public health emergency ends, every action that occurred that relied upon the existence of that PHE disappears, and you're back to the regulations being in full force. So yeah, it's and frankly, that piece of it is kind of tough to remember, because we've been operating under the PHE for so long that, I even have discussions with people who are very knowledgeable and going, so what waivers are we still operating under? Because they came so fast and furious that it was difficult at times to keep track of all of them.
Yeah, I'm just thinking that, we've been under this PHE for a year now, say, and we've really seen how flexible telehealth is, and what how it makes healthcare accessible to people who wouldn't ordinarily necessarily be able to travel to see their provider, right? So that's going to be something that stays. And what I'm thinking of now is like people in rural areas who are physically far away from their providers. They're going to rely on things like telehealth, which are becoming more and more sophisticated, more and more commonplace going forward. So that's only going to become more a permanent part of the ecosystem.
Yeah, certainly, hopefully, I will say, because there is work that needs to be done on that front. Yeah. One of the other big kind of impacts of the PHE was the fact that you could have, or not the fact, but the PHA also drove the federal government, and then frankly a lot of the states, under their own public health emergency declarations, to mandate equal reimbursement for telehealth services. So the reimbursement piece is very important, because pre-pandemic, I would say a lot of the driver for the lack of adoption of telehealth was that you would get paid nothing for it, or you get paid a fraction of what you got paid for the patients coming in the office. So that piece still has a lot of work left to do. And frankly, there's debate as to, should it be reimbursed at an equal amount, or should there be some reduction, because, the argument would be you don't have the same type of overhead, because you don't have to, you don't have people coming in, you don't have to maintain the same type of facilities, but, from that perspective, CMS, so the Centers for Medicare and Medicaid Services, which sets payment rates and coverage scope for Medicare, has implemented what it says is as much as it can do in terms of trying to, make permanent a lot of the public health emergency related changes, which is why in Congress you have a few telehealth related bills pending to, cover up the rest of that gap to get to permanence. And the same thing has to happen on the state level. Since we're in Massachusetts, we can use Massachusetts as an example. Massachusetts passed a law where they've permanently covered telemental health services, but have only extended the full coverage and full reimbursement for physical medicine for 2 years. After 2 years, we snap back unless they, in that period of time, you have further legislation. So as always, there's, healthcare is composed of an infinite number of layers. You peel back one, and then all of a sudden you discover there's probably 20 or 50 more to go, at least. There's kind of all those interactions, and then the other piece of it is it's still some of the stuff will exist, existed previously. So if you're talking, Nate, you raised a great point of it being helpful in rural areas. So pre-pandemic, rural is actually like the only place where Medicare actually covered telehealth. Although I will say with severe restrictions and limitations, so it's not like there is still some work to be done there. But again, it's there are so many different pieces to it. And then kind of the one that I see and I've focused on just a bit because this is where my company focuses a lot, but is remote patient monitoring. So that's a service that was also reimbursable pre-pandemic, where you're trying to gather, track, and interact with patient data that's being collected in their daily life to inform, how to address an acute or a chronic condition. So there are definitely a lot of opportunities there. But I guess maybe now I can shift back to just to level set everybody on HIPAA. So the Hipaa Basics, and I feel like this is always a good place to start, is especially given the kind of public discourse of thinking that HIPAA is being violated left and right. It only applies to 3 different types of entities that are holding health information. So it applies to a covered entity, and covered entities can be one of 3 different types of entities. It can be a health plan, so a health insurance company, or a self-funded health plan that's operated by an employer. So if your employer is paying to basically create the plan, even if it's administered by an outside insurance company, that self-funded component of your employer is a covered entity under HIPAA. Then you can also have healthcare providers, but not every healthcare provider. You can be a healthcare provider as defined by HIPAA, but not be a covered entity, because you have to both be a healthcare provider and you have to engage in an electronic transaction as defined by HIPAA, which means essentially means you're billing insurance electronically. So that is a very fine point, but it is one that becomes very important, because that's where like a direct to consumer telehealth company that's not billing insurance, but just saying, hey, you on the street, if you want to pay $15 for a quick consult, if that's your telehealth model, you're not going to be covered by HIPAA just doing that. And and I think that is often very surprising, because everyone, it's easy to just say, oh, it's healthcare data, it's got to be covered by HIPAA, which is, it's not the case. That can be used to kind of emphasize that, arguably HIPAA, either you need an expansion of HIPAA to maybe just try and cover some of those more direct to consumer cases, which didn't exist when the law was passed in 1996, or you just need a more comprehensive privacy regulatory scheme, or more comprehensive privacy legislation on the federal level. And then the third type of covered entity are healthcare clearinghouses, which frankly, I usually gloss over because most of the time you're not actually going to encounter them. Then the other category are business associates. So a business associate can be really any type of business. It could even be another covered entity, but the key is that you're going to be providing a service for or on behalf of a covered entity. And in that providing that service, you're going to be needing to use or create or interact with protected health information. So kind of the great examples here are, an outside remote patient monitoring company that is going to be helping to, maybe providing a platform where the data gets collected from the patient and then fed back to the provider or the clinician for interpretation, business associate. The cleaning company that comes in and might inadvertently see paper left on a desk, not a business associate. You might want to have them sign a confidentiality agreement, but they're not a business associate. And frankly, if you had them sign a business associate agreement, it's not going to be worth the paper it's printed on because they're not going to do anything to comply. And then the third category are subcontractors, which is really just a business associate of a business associate. So you can create a chain. And then the other piece is, what does it apply to? So it applies to protected health information, which is, the easiest way to think of it is it's basically any health care information held by a covered entity or a business associate about an individual. It's, there is a slightly more technical definition, but it is relatively expansive, and it's, for most purposes, it's you're not trying to pick apart those fine hairs. So then what are the components? Kind of the two major rules under HIPAA are, the first one is the privacy rule. So overall, the privacy rule is designed to establish how and when PHI can be used and disclosed. And by that mean that how and when it means, can it just be used as of right, or in, or in kind of the normal running of a, of a entity? Does there need to be explicit or specific authorization from the individual whose PHI is being used? Or does there just need to be an opportunity for the person to object? It's not the opportunity to approve, it's actually an opportunity to object to the use in a particular way. And on the whole, HIPAA is very permissive when it comes to allowing PHI to be used and disclosed without having to even go back and give the individual either the opportunity to object or to give explicit authorization. And if you think about it, it actually kind of makes sense, because a lot of the permissive uses are going to kind of these three buckets that are often referred to as the TPO, and it's treatment, payment, and healthcare operations, which when in each of those three terms is defined with, a few paragraphs each at least, or well, I guess more healthcare operations is multiple paragraphs. Treatment and payment is relatively straightforward. But there are very detailed definitions, kind of expanding on what each of those categories means. But kind of at the end of the day, it kind of goes in the direction of what are the common sense ways and times when information needs to be used for a healthcare business to actually operate and run. I think there can be, at this point in time, healthy debate as to whether or not there may be, those definitions are too broad and allow for much greater use of what people are assuming is sensitive information that's not being shared with other entities without their knowledge. But kind of the current state of the law is it can be very permissive, and a lot of what you actually want to end up doing is going to be allowable, so long as you actually have, if you have the right protections in place and also the right relationships in place with the entities involved. The other kind of major component of the privacy rule are what I kind of group together as patient rights or individual rights. So the right of access, which is one that has been gaining a lot more prominence and attention, and is also kind of an underpinning of the information blocking regulation, which, as I mentioned earlier, came into force yesterday or on April 5th, is, every individual has the absolute right to contact, a covered entity or a business associate of a covered entity that maintains their PHI and ask for either to come in and look at it or to ask for a copy of it. There are, I guess, to put it a little generously, some unintentional barriers that might be placed in the way of being able to exercise that right, or misinterpretations of what needs to be presented by the individual to get that access. But it is a very broad right to be able to access, and it's for the most part, most of the information that an entity will be maintaining about an individual. It's kind of getting technical. You can get access to what's called a designated record set, which might not necessarily be 100% of the information, but it's certainly going to be, probably all the relevant information that you're thinking about.
Yeah, Matt, an example I'm thinking of would be maybe a patient goes to a hospital to be treated, say he goes to the ER to be treated for a specific matter, an injury or something. And a month, 6 weeks later, he gets a letter from the development office at the hospital that says, John Doe, you were treated at our hospital. Wouldn't you like to give a gift to our annual fund? You're a grateful patient. Like that's a related business function of the data holder's business, right?
Yeah. So yeah,
That's
fundraising is actually
use.
fundraising is specifically covered within it.
Yeah, right.
Within HIPAA, and it's it definitely becomes a gray area. The foundations, and this is kind of a quirk. It's certainly a major quirk in Massachusetts because we have predominantly nonprofit hospitals, because a for-profit hospital is typically not going to have a foundation. The foundation, so kind of the foundation of a nonprofit is, typically a separate entity, because it's actually going to have, this is going a little far field, but it's going to have a different tax designation. The hospital or the nonprofit physician group would typically be the 501c3 that most people have heard of. A foundation is actually a different piece of the 501c subcategories. So it can engage in slightly different activities. So technically it's a separate legal entity, but they're usually also kind of what's called affiliated covered entities, which is a designation you can make where everyone, all affiliated entities will operate under one common set of HIPAA policies. So you do have that ability to use it. I think it's becoming a little bit more apparent that maybe practically speaking, you could be off-putting certain patients by sending that solicitation. I would say it's helpful to maybe be taking a slightly different tact on that at this point in time. But yeah, no, and that type of thing is definitely covered within the regs. So other kind of rights of individuals are the right to an amendment. So if you think there's something erroneous within, that you see within your record, you can ask to have it changed. That can generate back and forth, and it also doesn't mean that the bad information is just deleted. It actually means it's crossed out, notated that way, and then the correct information added. It's clunky, but it also kind of goes to different record preservation requirements. A request for an accounting, you can ask for, I'll call it all uses and disclosures of your PHI, but it's the way it's currently defined, and we're waiting on revisions to this accounting right that have been pending for I think a decade now, or maybe slightly less, but it's been a very long time. But it's kind of my personal viewpoint is I think it's somewhat useless. It's not, because right now all the treatment, payment, and healthcare operations aren't included. So you're really not going to see too much. And then another one is you actually have a right to request for communication in a particular way. You can say, don't call my house phone, to the extent anyone has a house phone anymore. I know I certainly I haven't had a landline except for the first year I was out of college. But this also goes to, you can ask for it to come to you by email or text message. Like you can direct how you want to be communicated with, or how you don't want to be communicated with, and that should be respected, or actually needs to be respected. So kind of moving to the other major component of HIPAA, which is the security rule. So this is, if the privacy rule is how you can use and disclose it, the security rule is how do you protect it, or how do you safeguard the data that and it is sensitive data that's being entrusted to the organization. So you've got three kind of main categories: the administrative, physical, and technical. So it's kind of a mixture between business operational style policies, control of the actual environment where an office might be located. In digital health, frankly, the physical controls oftentimes become superfluous because you're probably not hosting the data on site. You're probably using either AWS or Azure or Google to host your data, and you're never actually going to have. You might not actually have any kind of physical servers or anything like that hosting the data. But at the same time, you want to think about your workstations, meaning the laptops or mobile devices where the information could be accessed. So you're going to still, so while a bunch of it, as I said, becomes a little superfluous, there's standards around who can access the server room. You definitely need to be thinking about how are we securing the devices, and this is, the security rules where encryption comes in. At this point in time, if you're not encrypting a mobile device, you kind of got to question what thought process is going on there, because there had been so many breaches as a result of a flash drive. If people are still using those, given all this, the potential for malware now that has been identified with flash drives. But even like a phone or a laptop, if you have it unsecure, some like no password or not, or you're not having it time out appropriately, and someone takes it and they can get into the system, you've kind of lost the game. That kind of goes into the security rule, or each of the elements under those three main categories are broken down as either addressable or required. So if it's required, I think the meaning of that word should be relatively clear. It means you have to do it, and you actually have to do it the way that the regulation wants you to do it. So those are mostly the more, well, I'd say they're all fairly common sense in terms of the protections you want, but they're, the required ones are the ones that are more consistent across entity size or entity type. Whereas the addressable elements, you can either do it how it's suggested within the reg, or you can modify it as long as you're documenting, how and why you're modifying it. And this is where, kind of from my perspective, the security rule becomes very flexible. For example, a small business that's only dealing with data from one other one healthcare practice is going to have a much different type of system sophistication than, say, like a Google or an Amazon where it's hosting probably millions of different data, points of data, or hosting data from like millions of different customers. So you're going to want to address it in different ways. The other thing to remember, though, about the security rule is, and I like to think of it as, it's the foundation and the beginnings of actual good security. It is not prescriptive in terms of saying you have to do things in a certain way, which is frankly a good thing, because the last major update to the security rule happened in 2013, a much different world than it is today. So the reason I call it a foundation is it tells you how to have these kind of core elements that you can then build off of and actually be able to follow what are actually probably more, actual industry standards, or, industry best practices when it comes to security. And, I hear it a lot in healthcare, although it's probably true for many industries, NIST, which I can never remember what the acronym actually stands for. But it's a government agency, or quasi-governmental agency that publishes a lot of security standards and security guidance, which actually forms the basis of kind of the best practice. And you can find crosswalks of how complying with different pieces of the NIST standards will get you to be able to demonstrate HIPAA compliance. But the thing I always like to remind everyone I work with is, if all you're doing is complying with HIPAA, your system is not secure at all, and you may as well just have the doors wide open. So, kind of as I said, I think we've been talking to some degree about how this all applies to HIPAA as we've been, how it all applies to digital health as we've been going along. It really depends on what role you're playing. It's are you supporting a covered entity, or are you potentially a covered entity yourself? Or are you in both roles? Because HIPAA definitely states and reminds that a covered entity can be a business associate of another covered entity if you're providing, performing a service that's for its benefit. So kind of from my perspective, the key is run through an analysis, understand how HIPAA applies and how it operates. Then look at your business model and how you're running, or how you want to run your business, and then start going back and forth. If you're talking about if you're trying to ask yourself, are you a business associate? Frankly, there are a lot of good kind of decision trees that you can find by Googling. There's some big law firms out there will publish their decision trees, or I think the Office of the National Coordinator for Health IT might have one available now, but they are certainly very helpful resources. But you want to make sure that you have it right, because the other piece of it is, while I was talking about what HIPAA is, the other, I didn't talk about what does it mean to actually be compliant with HIPAA. So when you're compliant with HIPAA, it means you have a whole host of policies and procedures in place, because you have to have written documentation to demonstrate how you're meeting those standards. It's not, you can't just live by the standards. It's, you actually have to be able to prove it out. And then the other piece of it is HIPAA compliance occurs on an organizational level. So if you're a digital health company with, say, a mobile application, your application is not HIPAA compliant. Your organization can be HIPAA compliant, and appropriately setting up and configuring your application is a piece of your compliance, and it also can end up becoming a piece of the compliance of your customers, depending who your customer is. And then the other piece is, you might see a lot of services out there saying that they have they're certified HIPAA compliant, or some other kind of logo saying that they're compliant with HIPAA. That doesn't exist under the regulations, and there is no recognized body that can give out an official certification saying that you're HIPAA certified. You can certainly have outside companies audit you and be able to tell you where you stand, at least in their opinion, against HIPAA standards, but there is no officially recognized certification. So if anyone's kind of claiming that and using that as trying to use as a way to avoid answering questions, keep pushing, and also don't fall victim to it by being approached by someone saying, hey, we can certify that you're HIPAA compliant, and then you're all set to go. That can kind of undermine your credibility unintentionally. So kind of turning back to how does HIPAA impact data usage? I did talk about it a little bit. Obviously, as I said, the privacy rule is very prescriptive and broad in terms of describing uses and disclosures. I did talk a little bit earlier about de-identification, which has become a major topic, especially among digital health companies, because oftentimes, one of the key plays for a digital health company is to get data and be able to retain data from customers that you've generated to be able to further refine whatever product or system or analytical tool that you're developing, because the more data that you have, the more you can train it and the more you can learn from it. So maintaining the data as long as your client is active is probably fine, because you probably, as long as you need to have and be continuing to use that data, you can use it. You will want to pay attention to make sure that you're allowed to aggregate the data, though. If sometimes I see covered entities like large hospital systems either say you're prohibited from doing data aggregation, or it has to be part of the service that you're offering, or you have to get our permission to do it. So you want to pay attention to those terms. And then the other piece is de-identification. So I think I said earlier, HIPAA defines what de-identification means. You can either have, an expert be able to certify that using statistical analysis that the information is de-identified. I personally don't actually know any experts who can do that. I've seen other lawyers that I know hunting around for those folks, because I think they're in short demand, because frankly, most people rely on the other kind of de-identification safe harbor, which is to scrub out a whole list that is explicitly laid out in the privacy rule of the list of identifiers that need to be removed for data to be considered de-identified for HIPAA purposes. So again, you have to be very careful there, because it's very clear about what needs to be removed. And if you've appropriately de-identified, then the de-identified data is no longer PHI, and it is also no longer subject to HIPAA. It's leaving aside a much broader debate among individuals as to whether de-identification is even possible anymore in this day and age, with all the different data sets you could apply even to de-identified data to then be able to re-identify it. Um, it's to some degree an academic discussion, I would say. HIPAA still has a de-identification standard and allows for it. So it's at this point, I think if you're complying with those pieces, if you want to have de-identified data, you're probably on decent footing. And actually, before I get to information blocking, as I'm going through the slides, I realized the one thing that I probably should have highlighted with the slide is, when I was talking about that you've got different categories of entities, the covered entity and the business associate, before a covered entity can share PHI or allow a business associate to create or maintain PHI on its behalf, you need to have what's called a business associate agreement in place. 90% of that business associate agreement is covering elements that the regulations specifically mandate have to be into that in that agreement. So it's saying that business associate will comply with all the security rule. It's laying out different components of the privacy rule that you have to comply with. Setting up some restrictions on other use and disclosure, and then there's also 3 elements where a covered entity has an obligation. But it is the obligation of the covered entity to make sure it's in place. And the government's actually fined a couple of covered entities who shared PHI, either because they never had a BAA in place or it took years for them to get there. But while a lot of the BAA is dictated by regulation, you also do still need to pay attention because I like to call them the extracurricular provisions that get added in. Oftentimes you'll see mandates for insurance coverage. The regulations don't contemplate that at all. So insurance, generally, it's kind of pushing some type of cyber liability or breach liability coverage. You'll also see potential requests for reimbursement of costs that are caused by a breach of the business or a breach caused by the business associate, and kind of a parallel to reimbursement, which is usually meant to cover specific out-of-pocket costs. You can also see what's referred to as an indemnification provision, which boils down to if the covered entity is, faces a claim or potential liability from another party because of alleged action by the business associate, they're going to look to the business associate to cover, potentially defend it. So that means you have to, if there's a lawsuit, that a business associate's going to be paying for that, or to, once damages have been determined, to make them whole, or even cover responding to potential claims. So you definitely want to be looking at all those terms, and you're probably not going to be able to get them knocked out altogether, but you can try and negotiate and get them slightly more reasonable. Although I will say, on the whole, over the past couple of years, I've seen those kind of evening out. A few years ago, they've been a little bit extreme in one direction, but now I think I'm optimistic that it seems to be that there's going to be, some level setting is occurring, which has definitely been helpful. But definitely a key element when you're working within in the field. So was there a question?
No, keep going. I
Okay.
I want to make sure we have time at the end for a Q&A. So I just want to be conscious. It's 6:10 now. So why don't we plan to spend the last 10, 15 minutes on Q&A?
Sure. Yep. No, I can buzz through the last couple pretty quickly. So information blocking, as I said, this is still a new set of regulations. Full implementation got delayed because of COVID. The government allowed the can to be kicked a little bit, but the basic premise is you have to allow patients or individuals to get access to their information, and it's arguably a broader right than the right of access under HIPAA. And it's also looking at creating API connections, so outside apps can hook into a provider or to a healthcare facility systems and be able to pull out data. There are 8 exceptions as to when you can still say no, but they're trying to be limited, and it's definitely a major step or steps in the direction of freeing up access. And there are very it's making it happen a lot more quickly, and it's I think it's going to catch some people a little bit flat-footed. So all of the stuff, kind of remember, as I've been talking about, is if you're fully within the healthcare system. As I said, if you're maybe direct to consumer, or in a vein where you're not going to be falling in what's I would frame as a traditional healthcare system, don't forget about the FTC. So the FTC, generally, you're thinking about unfair and deceptive trade practices. So meaning, don't lie to people, don't hide the ball in terms of how you're operating. So I will say, be honest and be straightforward. People might interpret those words differently. The being honest and being straightforward from the business perspective likely means you're going to actually state what you want to do within your terms of use or your privacy policy. Even, I will cynically say, I'm sure most, 99% of people don't read them. I know I've prepared a lot of them, and I know most people haven't read a single word that I've written. Every once in a while you'll see, something in lawyer circles would pop up where a company got, funny and put in, some type of line just to see if someone was actually reading the policy, like insert a joke in the middle. And, it would take years for that to be found. But, as from the company perspective, as long as you're including it in there, that's a legally binding, statement. And if someone complains and you can point out, oh no, our terms of use said it, you're not being unfair and you're not being deceptive in most instances.
Yeah, I'm also thinking that you want to be aware of, you don't want to run afoul of state-based consumer laws. Like I'm thinking of Chapter 93A, which is it's a more of a consumer-based statute where the consumer has a lot of rights to a lot of state-based rights that complement the FTC rights.
Yeah, no, exactly. It's, there are definitely kind of corollary laws and requirements there. It's, as you said, it kind of all comes down to unfair and deceptive practices. It's
right.
Differences, and you're definitely right. A lot of these kind of consumer protection laws in the state level allow individuals to have a right of action. So you're not just waiting for the government to do something. And then the other kind of piece of it is, FTC does have privacy and security requirements. So you still can't have the gates wide open. The other piece that's creating a lot of difficulty are the kind of the proliferation of state level security law or privacy schemes. California and now Virginia are two of the biggest examples where they have very comprehensive ones. I would say helpfully, if Hipaa is applying to your operations, you're usually not having to comply with these laws. Because they recognize that they don't want to be doubling up on requirements. But it's definitely a growing area, and one where if you're going to be subject, you're probably there might be thresholds before you become subject to them, but you're going to have to almost essentially do a 50 state survey to understand all the different requirements. And then the last thing that I wanted to just touch on, because I understand this came up in one of the prior sessions, is the concept of data ownership or data control. I often will see, and I will say this pops up on social media probably a couple times a year, where a lot of individuals might argue that they want to own their data, and that a hospital or a physician group, for example, shouldn't own it. Currently, as the law stands, New Hampshire is the only state where individuals own their own medical records. I would actually argue that control is a much better place to focus, because ownership, those rights can be eroded quite easily. There can be laws, there can be regulations that carve out and limit the scope of what ownership means. If you kind of one analogy be, think about it, you can own a house and you think you own the land that you live on, but the government can come by and they can take what's called an easement, where they can say, oh no, I can go across your land and you can't do anything about it. Same thing could happen with data if the government found that there was going to be some public health benefit for being able to access it and use it for some other right. You could easily see that being undercut. Whereas if you can control how it's being used, or have a say in how, which may mean you have a say in how it's being utilized, I think that could be more powerful, especially when you combine it with the increased right of access and the increased ability to get it. I think it also then kind of starts going in the direction of, in this, I think it flows out of control, is being able to restrict, commercialization of the data by entities. HIPAA right now restricts, sale of identifiable PHI or, using it for extreme marketing. So you do have some, ability to lock it down there, but I think it's, getting more into those aggregated de-identified data sets where people you're pushing to be able to have more control before the data can get to that de-identified stage, because it's, there is a lot of value in there. And the question is, well, if a system is recognizing a lot of revenue from that, why can't that get pushed back to the individual? But it's I think that's a very broad discussion and one that's definitely an evolution. But it's that's why, at least personally, I fall more on the side of data control as opposed to ownership, because I think ownership can be illusory, and I think when you actually, or at least I feel, when you start parsing through the arguments that people are raising as to why they want ownership of their data, they're really talking about control. And I think control might potentially end up being able to be a stronger legal right than ownership. So kind of, hopefully I left a little bit of time for Q&A. So what I will do to help that is I'll stop sharing my screen, so that way if people have questions, we can all see each other.
Yeah, well, we do have some questions already in the chat. Great. So I'll start with a question from Matthew Swenson, who asks, to you, Matt, how often do you see health tech companies, startups fail or significantly alter their product or their plan once they realize the regulatory hurdles they would have to cross to get where they want to go?
So I probably have somewhat of a biased view on it, because I am suspecting that the ones that would be reaching out to talk with me are already cognizant of that. So they are probably set up better from the start, because they're either asking early on, or they were starting development with an understanding to some degree of, what the restrictions or requirements might be. I think that example I gave at the beginning of the one client I had, even though they had been in the healthcare space before, they were kind of coming at it from a new angle. So I would say they're probably one of the lucky ones, because even on the whole, most startups are not going to succeed. That's just kind of the nature of the business, but I think the more you can ask, and when you're in the planning stage, so that way, if you haven't burned a lot of capital yet, and have to shift directions, but at the same, so I would say the answer is, I don't know if I have a clear one about how many fail just because of that issue. I think the other issue is, you can have a really great idea, but maybe it's not the right time for the market, or, even you think you're going to develop in one direction, but it's not necessarily the regulations, but more the market access or the market entry points, or frankly, the ability to actually make money, where you see you have to end up pivoting, because I've seen that where direct to consumer ideas pivot to being B2B within the healthcare industry ideas, because it was recognized that, we probably wouldn't be able to get sufficient revenue from a D2C, the D2C model.
Very interesting. So going back to what you just talked about earlier about the discussion of COVID and in the era of digital health, could you just talk a little bit more about how you see COVID changing the legal landscape in this space going forward? For example, when do you think, if and when do you think HIPAA would become more relaxed with respect to digital health?
Yeah.
And if so, what would that look like?
Yeah, so I don't think you'll see HIPAA become more relaxed, because I would say once you actually have an appreciation and understanding for how HIPAA currently is set up and operates, it allows for a lot of innovation. Kind of oftentimes when I see complaints that, oh, HIPAA is stopping me from doing this or stopping me from doing that, either it's from a misunderstanding and misapplication of HIPAA, or the issue is actually state law. Because as I said, remember up front, with the federal system, HIPAA sets the boundaries out here, but then states narrow it down to here. So especially when you're thinking about like right of access issues, it's usually state law which is saying, oh no, certain types of records get special protection, and you have to jump through more hoops to get to it. And also kind of like the privacy perspective, there can be questions that, there can be concerns that HIPAA doesn't allow for the data to be used in a particular way. But if you're in a business associate role, you can actually get a lot of data if you're using it to support the covered entity. So I think that to me is actually one of the dangers of what happened. Although I would say even with COVID, it's, it was more on the specific telehealth of, you didn't have to have a system that was within HIPAA standards, but it's, in terms of the kind of collaboration, coordination, overall use of digital health, the companies that know what they're doing have the right protections in place. So I'm not one of those people who thinks there needs to be a fundamental either scrapping or redesign of HIPAA. I think arguably you just need more of a comprehensive privacy scheme, so that way you're filling in the gaps or the limitations of HIPAA. But with that kind of comprehensive scheme, I don't think you want to get rid of HIPAA. I think you want to have it alongside, and I think it still makes sense to treat healthcare differently than you would, general consumer privacy, which is kind of what you end up seeing with, I think like GDPR in Europe. It has, different treatment for healthcare than the broader, like, for example, everyone's always enamored by the right to be forgotten, so the right to be able to request that your data be deleted, not going to happen in healthcare. There's, too many other, some people would say this is just an excuse that, that there's other obligations that exist to have to maintain that data, but it's also, you want that, you don't want to tell your hospital, oh, delete my data, and then have to go back 2 years later because of an unexpected issue. Now they do something to you that if they had their whole record, they would know, maybe you had an allergy and they shouldn't have done something, but because they couldn't access it, there was an issue there.
Yeah.
But I think, as things start to normalize again, and, in terms of PHE, I think I've heard musings that it'll, I guess, stay in place maybe through the end of this year. So you've got, that bit of runway before before it would happen, or at least there would be like 60 to 90 days advance notice before it's going to be revoked. So, you've got time to go back through and get used to having to comply with everything again.
Another question, you touched on direct-to-consumer products, I guess you'd say, and it does seem to me that that's really where that sort of niche is really where a lot of innovation is happening in this space. And the example I'm thinking of is something that maybe some other people have noticed you see this a lot during like men's sporting events, like the NCAA tournament over this past weekend. You see a lot of commercials for like men's health kind of startups, like direct-to-consumer startups around like men's sexual health, men's other types of services. It seems like that's really where the innovation is. And I'm just wondering, you said when you're in that space, obviously, if you're in a direct-to-consumer model, I guess, you really have to be concerned about all the nuances in all 50 jurisdictions that you're potentially going to dip your toe into, right? I mean, you really have to start the analysis of looking at the whole panoply, a whole panoply of regulatory frameworks that exist and how you're going to fit in there, right?
Yes. Yeah. So, I mean, it might not be, like a fraud and abuse issue or HIPAA necessarily, but it's, you're definitely right where, you'd have the state level privacy stuff, but it's also, like for those, newer services that have certainly raised some legal eyebrows of, basically, the harsh perspective is providing ready access to prescription medication without a backup, actual examination to determine if it's medically necessary. You have questions: are people overstepping prescribing bounds? Are people appropriately licensed? Because there it's a form of telehealth, and in most cases, the clinician who's providing advice and then certainly prescribing in that case would need to be licensed where this patient is located.
Yes.
So you're starting to hear, there are interstate licensure compacts. They're certainly not universal at this point across the whole, all 50 states. So you do have question. There are, which is, that kind of piece is a whole different area that I didn't even touch on. But it is one that raises a lot of complications because some of these telehealth companies will require or push to have physicians licensed in all 50 states.
Yeah,
that is a very time-intensive and labor-intensive process, both for the company and the physician. because then you have a whole host of requirements that get imposed on the physician because of that. But it also is kind of, as I said, kind of pushing the boundaries of the clinician-patient relationship. Questions about medical necessity of some of the stuff. And do you have the right basis to be prescribing? So it's you can end up in all these gray areas, and I think you want to if you're the company, you want to make sure you've got a good grounding to make sure you're not going to be stepping into something without at least having eyes open as to the risks.
Yeah, definitely. It's a lot to think about. Well,
yeah,
Matt,
it kind of comes back to, I was just going to say, I mean, like, that was the one, that was one of the other, things that when I was at my firm, my mentor explained is, as a lawyer, the job is to explain the risk and to lay it out, and then the business gets to decide what the risk tolerance is.
Right. That's well said. Yeah. Well, Matt, you've given us a great overview of the regulatory and legal considerations in digital health and healthcare generally. So thanks for sharing your expertise with us for this great series.
Yeah, no, again, it's my pleasure to be here. And it's, if you want, I can give you the slides and you can be able to send it out to all the attendees, because it has all my contact information at the end.
Yes.
So, always happy to have conversations with folks.
That would be great. Yeah, thanks for that. So Danny, I'll kick it back to you if you want to do the wrap up.
Absolutely. Well, hey, thank you so much again for that wonderful presentation and Chad. I definitely learned a lot from it, as someone who's working in this space as of now. And I'm sure I got a lot of private messages actually as we're going through the slides to say some from Korea who are up here. It's 7:30 here in the morning, and they're up to listen to this, so it's pretty nice. But that being said, this wraps up the session for today. I know that for the next one we'll be talking a little bit more about commercialization of digital health, and what it's like after you go through the data management, after you go through the legal hurdles, like what remains at the end, right, in a sense. So we definitely look forward to seeing you there, and again,